Welcome back, everybody, to A-Level Politics. We're continuing to talk about the nature and the sources of the British Constitution, and we're going to move on to talk about some of the most fundamental basic principles of the UK Constitution, beginning in this lesson with the idea of the rule of law. So the core principles over this lesson and the next few lessons that we're going to look at include this idea of the separation of powers, which we'll get to in a future lesson, the principle of parliamentary sovereignty, which is of course very core in our understanding of how the UK Constitution works, the rule of law, which is of course what we're going to be focusing on in this lesson, and this idea of operating within the broader context of a constitutional monarchy. What do we mean when we think about the idea of a constitutional monarchy? Because unlike most states, we are both a country that has an uncodified constitution, but we're also a country that has a monarchy still, and has an acting monarchy that still has legal power within the system of the creation of law itself. So we'll think about what it means when we think about the idea of constitutional monarchy and the idea of the royal prerogative and the influence that that has. And we'll also look at that in more detail when we think about the lawmaking process, when we look at Parliament more specifically, as well as the influence that the monarchy has over the executive branch. So let's begin first with this idea of the rule of law. Now, the most basic understanding is that the rule of law constitutes a set of ideas whereby it is desirable for a state to be governed by certain rules. The idea that things should be governed by rule. Now, according to Aristotle, we have this idea of a government of laws, not a government of men. The idea specifically referring to this principle that it is not people that rule us, it is the law that governs society. A government of laws. We are to be governed by the rules themselves rather than the people who maybe create the rules, or in the cases of earlier centuries, the idea of the monarch that has this divine right to rule. Rather than having this idea of a divine right to rule, we have this idea of the government of laws, not the government of men. Now, the rule of law does, however, have many different interpretations, and it's beyond the scope of an A-level politics course to think about the idea of the rule of law in any great significant detail. That's something for undergraduate university courses in philosophy, in law degrees, in political science, etc., etc. So if you're somebody who is studying A-level politics right now and is looking to potentially do a law degree or do a philosophy degree or a politics degree, then this might be something that you will end up doing in far more detail and have a greater understanding of as time goes on. It's recognized internationally that we have this idea of a rule of law, and for the most part, the rule of law is a principle that is applied in the vast majority of Western liberal democratic systems. It is a system that is also arguably applied in certain areas of international jurisdiction as well. So, specifically, the idea of a rule of law, the idea of law being the constitutional framework and the foundation for the rules that are established, at least in the context of England and Wales, this goes back and dates back to the Anglo-Saxon period, where we have this idea of a contract that is established between the ruler and the ruled under the obedience of the monarchy. In this case, and in the Anglo-Saxon period, we're talking about, of course, the king. The first true queen of England was Mary I in the late 1500s or mid 1500s specifically. Now, the reason why I'm delineating here between the United Kingdom and England and Wales is because of the fact that legal systems in England and Wales is very different to the legal system that we have in Scotland and Northern Ireland. And England and Wales essentially merged their legal systems together all the way back in the period of the Angevin Empire, or even, I believe, potentially before that, in the 1200s. And the system of law that we talk about is a system of law in England and Wales. And when we think about constitutional law, more broadly, that applies to the overall UK, because we're thinking about things like devolution, for example. We think about parliamentary sovereignty over each of these different areas. But there is often a delineation that is had between law in England and Wales and law in the United Kingdom. So, for example, if you ever go to a university and you ever go and study for a law degree, for example, and you decide to do criminal law, or you'll have to do criminal law, you do a module on criminal law, you will not do a module on UK criminal law. You will be doing a module on criminal law within the jurisdiction of England and Wales. If you go to Scotland and study Scots law, you'll be doing those kinds of issues within the context of Scots law. So that's why I've just mentioned England and Wales here. So the English version of the rule of law stresses that the key foundational concept of a rule of law is this idea of the common law. Now, the common law was built out of the reigns of the Angevin kings within the Angevin Empire in the 1200s, the period of around the 1200s. But it does date back to the Anglo-Saxon period. There are definitely studies of law under the reigns of Alfred the Great, for example. And even these ideas date back even further to an extent to this idea of a Roman law tradition. According to Koch, the rule of law protected both the ruler as well as the subject, the ruler against criticism and the subject against tyranny. So it essentially limited the powers of both the ruler and the subject in that regard. So let's think about the interpretations of the rule of law. We have this idea of a core rule of law principle, and this is the basic idea of the rule of law that we have explored in this lesson and that we have been talking about. It means government by law informs on general rules as opposed to it being the discretion of the ruler, okay? So instead of it being the arbitrary discretion of a particular ruler, whether that be a monarch, for example, then this is delineated from that, because when we think about the discretion of the ruler as cited here on this presentation, we're talking about the arbitrary discretion of the ruler, which is how it used to operate when we had monarchs that had discretionary power that came from this idea of a divine right of kings. And so what we have here is the idea that the rule of law protects against this. Government by law informs on general rules, rather than this idea of the ruler tyrannically and arbitrarily making decisions on the basis of their own particular discretion. In addition to this, we have a further interpretation of the rule of law, which is this idea of the quote-unquote amplified rule of law. And this claims that certain principles relating to ideas such as justice and fairness are inherent in the notion of the rule of law itself. Now, what we mean when we constitute conversations about justice and fairness, and we can often, in the context of legal studies, throw in this word that we refer to as equity, the idea of equity within a system. All of these things are relatively fluid notions, but they do fundamentally relate to this idea of a rule of law, according to this amplified approach to the idea of the rule of law. Now, what does justice mean? What is fairness? What is equity? Are all very interesting questions that are very deeply philosophical, and you would do if you were doing a philosophy or a political science degree. But one of the ideas that is inherent in this is that the rule of law is justice, the rule of law is fairness, the rule of law includes principles of equity. And then we have this idea of the extended rule of law, and this is seen as the most ambitious top-level idea of the rule of law. It's not just a basic idea that essentially gives us the rules that are created by government rather than the arbitrary decisions of kings. It is instead a more ambitious, extensive idea. It claims that law encapsulates the overarching political values of an entire community, a societal community at large. We also think about distinctions that we can make between a formal versus a substantive version of the rule of law. According to Craig, 1997, the formal version of the rule of law centers on the shape and application of the law itself, whereas it is in the substantive versions we're talking about the content of the law. What does this mean? What does this delineation actually signify? Well, the formal version is talking about the law as an idea, the law as a consequence that is broad and that we can think about in relation to how it operates, how it looks, how it works. Whereas the substantive version of the rule of law doesn't necessarily look at the law as a whole entity, but it looks at specific substantive ideas relating to the content of the law, what the law actually says, what different laws say, how these laws are applied, and principles that are applied therein. So these are another ways in which we can delineate between a formal versus a substantive rule of law. So we sort of have two different dimensions of delineation when we think about the rule of law. We have this sort of vertical dimension talking about the level of scope that the rule of law essentially abides by, with the idea of the core rule of law, the amplified rule of law, and the extended rule of law. And then there is this horizontal examination of scope relating to the formal versus the substantive versions. And so essentially, when we think about the rule of law, as I mentioned at the start of this lesson, it is a broad topic that is something that for an A-level student is probably not going to be, you're not going to be getting into in too much detail. When you do a university degree in these kinds of subjects, that's when you really start to get better understandings and have a much deeper appreciation for principles relating to the rule of law.